Hello, welcome students to our next class. So till our previous class, we had completed till section 9, and today we will complete from section 10 to section 14 of Bhartiya Sakshiya Adhiniyam 2023. So this time I have tried a new way, okay, a new way of presenting the video. Okay, various images are there and the theme is also new. So maybe you enjoy it. Okay, so let us start. So let us start with section 10. What section 10 says is facts determining damages. So many of you who are studying their LLB course or are into practice must be knowing the meaning of damages. What do you mean by the word damages? Damages can be said to be the amount which the court decides to be paid by one of the party to the other party in the form of compensation. Okay, so there are various cases where compensation are to be paid from by the wrongdoer to the victim. Okay, so what would be the amount of compensation, that is also decided by the court, and any fact which helps the court to decide what ought to be the proper compensation or damages are relevant, and evidences to prove those facts are admissible. Okay, so in the bare acts language it is written that in suits for damages, facts tending to enable the court to determine the amount are relevant. Okay, so the amount to be determined are relevant, and if I try to explain it in simple manner, it says that when someone files a lawsuit seeking compensation, any evidence that helps the judge calculate the exact amount of money owed is considered important and admissible in court. For an example, if there is a farmer who sues a chemical factory for contaminating his irrigation water, okay, he sues the factory owner that due to the emission of various gases and chemicals, if his crop is damaged, okay, his crop is totally wasted. In that case, how much compensation is to be paid by the factory owner to the farmer? In that case, the first evidence is that the crop yield before pollution, if the pollution had not taken place, what would be the crop yield? Okay, what amount of crop had been grown into the field? That is a relevant fact. Okay, and this fact will help the court to determine the amount of damages. Current market prices will also help the court to determine the damages. Medical bills, cost of alternative water sources, okay, as the water has been contaminated by the emissions, so that cost will also assist the court. Those facts and evidences will also assist the court in order to reach into the conclusion of the amount of damages or compensation. So section 10 is over. Now let us move to the next section, that is section 11. Okay, rights and customs in question. So rights and customs are also when the rights and custom is in question before the court, whether there exists any right, okay, adhikar, okay, and custom, riti, rivas. If these things are in question, whether any right exists or not, or whether any custom exists or not, in that case, any fact which enables the court to believe that those right exists or those custom exists are relevant fact. Okay. So uh, how a right or custom is proved? Any past transaction, okay, any past transaction or any particular instances in past transaction or instances which has taken place in past, the evidences of those transactions and instances are relevant. Okay. So in the direct language also, facts showing the existence of any right or custom are relevant. Okay. Now if we try to understand in an easy manner, if a case involves traditional rights or customary practices, evidence proving these customs actually exist is admissible and important. So how will the person who is trying to prove the right or custom will establish those rights or custom? Through previous transactions and previous instances. Transaction means if something is taking place in a serial manner, okay, for continuous period of time. And instances means for even a single instances, some custom or right can be established if it is practiced even for a single or for one time only. Okay. Now, for example, village water rights. Suppose there is a village and there is a question before the court that whether a well which is there in the village, well means kuan, okay, is ancient, is a public property or not? Okay, that is it true that any person can have access to that the water of that well? Okay, so if any person tries to block the usage of that well to any person or any family, some old photographs, village elder testimonies, and historical records can be given as an evidence. Okay. In that case, if the court believes in these evidences, court will recognize the traditional custom and restores community access. Okay. Now let us move to the next section. See, state of mind and body. Okay. So what do you mean by state of mind? State of mind means what is the condition of mind. Okay. For an example, if someone has some intention, okay, or good faith, intention, good faith, goodwill, or ill will towards any particular person, okay, any person, these intention, good faith, goodwill, ill will are all state of mind, and these state of minds are relevant fact and can be proved before the court. In the same manner, state of body, okay, state of body is also relevant, or bodily feeling is also relevant when state of body or bodily feeling is in question. For example, if someone is ill, physically ill, his illness can be proved if that illness is in question before the court. Okay. In the same manner, if someone is feeling that his left half of the body is paralyzing, his feelings are also relevant if his such bodily feeling is in question before the court. Okay. Now let us move to the next section. Section 13 states that when the question is before the court that some fact or act, any act, okay, suppose the act is of murder or act is killing, Okay, so is the killing intentional or it is accidental? Okay, in that case, any fact which will help the court in determining whether it is intentional or just accidental without any intention or without premeditation is relevant. And if there are if the killing is the result of various transactions, okay, in that case those the evidences of those transactions will also be relevant. Okay, for example, uh, if uh, someone's car is burnt, okay, the car is burnt, in that case, if the question is before the court whether the person whose car is burned has himself burned it or the burning was just accidental. Okay, so and it is shown before the court that the person whose car is burned has in many occurrences or in many instances his car has been burned in the same manner in previous in past also, which proves that he might have an intention to burn the car himself so that in order to acquire the insurance money. So those facts that his past burning, the fact that his car has been burned in the previous instances also is relevant. Okay, now let us move to the next section, that is section 14. Okay, now facts. So in section 14 says course of business. Okay, course of business. Facts showing the existence of a course of business are relevant. Look, uh, if the question is whether a particular thing has happened or not, and it is proved before the court that it, with the natural course of business, it would have been done, then the court will believe that the thing would have been done. For example, the if A dispatches a letter to B, okay, through post office, and the question is before the court that whether the letter has reached B or not. Okay, in that case, A may prove before the court that after posting the letter in the post office, it is it should be assumed that the letter would have reached to B, as it is a course of business of the post office. It is the natural tendency of post office to receive the letter and post it to the person who has been intended to be the transferee of the letter. Okay, so this is course of business. Easy explanation is also given here. When a case involves business transactions or commercial disputes, facts that demonstrates how a business typically operates, it standard its standard practices, procedures, and patterns are important evidence. So evidence may be given that by posting a letter to the post office, the letter must have reached to be in the course of business. Okay. So today let us keep till 614 section 14 only. Okay. And in our next classes we will cover the next important sections of the Bhartiya Sakshiya Adhiniyam. Till then, goodbye, keep working hard. Okay, and you must tell in comment section whether my this method is helpful or not. If it is, I will continue in this method presentation only, this method of presentation only. Otherwise, I will resort to my previous method. Thank you. Thank you all. Goodbye. Have a good day. Thank you.